Hi, I'm Reed Bloodworth, an Orlando, Florida attorney. Since 2004, I've practiced business litigation, commercial litigation, and estate and trust litigation. Today, I want to talk about communications I see parties make when they believe a breach of contract has occurred. When I say parties, I mean the potential plaintiff and the potential defendant. Oftentimes, when a potential breach has occurred, the parties are very tempted to begin a series of email exchanges or telephone call exchanges. Sometimes this can be helpful, sometimes it can be pretty damaging to your case. So I just wanted to run through a few examples. When a potential breach occurs, typically it is the potential plaintiff who will notify the potential defendant. A very general example would be, dear defendant, the contract we have states that you were to pay me $500 by the 15th. You failed to make that payment. Please make this payment immediately. That type of communication is fine. It is within the realm of the contract. If it was an installment note or something of that nature, it's a calm, it's collected, it is a factual statement. As a potential defendant, she may respond that I don't owe that payment because of some circumstance that has arisen, or perhaps the potential defendant believes that potential plaintiff breached the contract and that's why there's no payment owed. These communications are generally okay. They do establish potential evidence for any lawsuit going forward, and oftentimes they lock the parties into their potential positions. So, some recommendations. When there is a potential breach of contract, any communications should be calm. You do not want to immediately fire off a very nasty email or begin name calling or make statements that are untrue, because you don't want to open yourself up to some other type of lawsuit. And while it is okay for clients or the parties to exchange some communication, maybe attempt to work out the potential breach, it would be very advisable for the parties to engage counsel. And before any communication is made between the parties, ask the counsel for their advice. Oftentimes, the attorney will give you advice that will help resolve the issue quicker, rather than going into multiple exchanges with each other. Also, oftentimes involving an attorney, it will encourage the other side to resolve this matter. If at some point the parties appear that there's just not going to be a resolution, it's beneficial to have already had counsel involved, because they're aware of the situation and they'll be able to immediately begin the lawsuit representing you. So again, my name's Reed Bloodworth, an Orlando, Florida attorney. Give me a call. Let's discuss what happened to you.